Welcome to the Dealmaking with Laura DiFrancesco podcast. I'm Laura DiFrancesco, your host. We're talking all about mergers and acquisitions, buying and selling small businesses, as well as corporate law. We are taking our experience closing over $10 billion of transactions since founding Dean Street Law 5 years ago, and my experience being an M&A and corporate attorney for over a decade and making it accessible to you as an entrepreneur. I hope that this helps you in navigating the complex world of mergers and acquisitions. And also, we're always happy to be a resource for you here at Dean Street Law. You can always apply to work with us through our complimentary consultations linked in our show notes. And a huge shout out and thank you to everyone who's subscribed and left us a 5-star review. If you haven't yet, be sure to subscribe and also leave us a 5-star review. It's one of the best ways to support us as a small business. And also be sure to share with your friends and colleagues on social media, through text, email, or however is easiest. It means the world to us that you're supporting our content and helps us make more to support you in your journey. Welcome back to another episode of the Dealmaking with Laura DiFrancesco podcast. I'm Laura DiFrancesco, your host, founder of Dean Street Law, and author of my new book, Entrepreneurship Through Acquisition, A Legal Guide to Buying a Small Business. If you haven't checked it out yet, it would mean the world to me. You can check it out through the link in our show notes or deanstreetlaw.com/links. You'll find the first chapter where it'll be available for purchase. And when you do, you can download the first chapter and leave me a review. You can leave a 5-star review on any of the platforms where you can purchase the book, or just send us a review. It means so much to us to get some early readers and early reviews. You can send your 5-star review at etareview@lauradifrancesco.co, and we will send you a pre-LOI due diligence request list as a thank you for your support. So if you haven't already checked out the book, shared it with friends, it would mean the world to me. So thank you guys all so much for your support for the book. And I'm so excited to chat about today's topic. We're going to be chatting about non-competes, and a non-compete is the covenant not to compete with the business once a seller is selling the business. Now, non-competes you may hear a lot more about from an employer-employee perspective than selling a business and buying a business. And so there's been a lot of heat around non-competes from an employment perspective, from the FTC ban that was enacted and then now in litigation and being contested. So there are a lot of ongoing conversations, but it's always been super clear that non-competes are permissible in the purview and application of buying and selling a business. So we're going to specifically be talking about non-competes in the realm of buying and selling a business in mergers and acquisitions. And we'll also touch on how to consider non-competes with respect to an employer-employee relationship as well. Lightly touch on that. So first, let's talk about the basics of non-competes. So the value of non-competes, the reason of non-competes, and why you see them in almost every single transaction is because so much of the value of the business is beyond the numbers. It's beyond the assets. It is the goodwill of the business, the customer relationships, the vendor relationships, the essence of the business as a whole. And when you have an owner of the business, they tend to have a lot of connection, whether it be because they have direct relationships with customers or vendors or suppliers, or because they know and have knowledge of the inner workings, the systems, the processes, the people, how it's all made. And so if there's one person that could take your business down tomorrow, it is the current seller. And that's just a matter of fact. The seller will always have more knowledge, experience in the business generally than the buyer, because the seller's been doing it, they've been operating it, they know the ins and outs, they know the skeletons, they know the opportunities, which are a great thing and can be a great opportunity for buyers to transition into a business successfully. And one of the protections from it going awry is for having a non-compete. Now, this is going to be required in most financing situations, and every single SBA loan will require a solid non-compete. So it is pretty expected from buyers and sellers that a non-compete will exist. Most people cover it in their LOI, although some don't, and it becomes a bit more of a conversation than they realize. I have to say, non-competes, they either don't matter at all to the seller or they matter quite a lot to the seller. And that, I think, just depends on, one, their risk tolerance, and then two, their plans for the future. So generally, when you're talking about terms, you're negotiating within the agreement. We both agree that there's going to be a non-compete. So what is the scope of the non-compete? What is the term of the non-compete? And what is the proximity and territory of the non-compete? So scope, what constitutes competition of the business, what is the term, how long it is, and then what is the location and territory that it will encompass. And so for it to be legal and valid and binding, no matter what, there are still, even though it's permissible to have a non-compete, there are still boundaries to it. It has to be reasonable in scope, reasonable in term, reasonable in territory to be effective and to be something that's enforceable. So you're going to have to work with your attorney heavily to make sure that this is tailored appropriately to the transaction. Now, within those bounds, there can be still a lot of negotiation, because one of the things sellers are really going to be concerned about, and that should be a conversation between the parties, is, well, let's say this is their nest egg. This is, generally a business is most sellers' primary income, and that's their nest egg, and that's their retirement. And what if something happens? What if their assets dry up? What if there's a traumatic incident in the family and they have costs way, way more than they expected? The concern for sellers is, how can I still make a living if I have to? I may not want to, but if I have to, how can I still make a living? And truly, it should be reasonable in scope that is not an issue, that if something happens, because this tends to be a seller's primary skill set, that if something happens, there is an opportunity. Now, how it's structured could be many different ways. We've had it structured where the scope is going to be anything that competes with the business. So it is the business and the definition of what the business does at the time of closing. But sometimes it's negotiated to be more expansive than that, and expansive into what the buyer intends to do if they plan on rollout goods or services, or if they're a strategic acquirer and they're already providing other goods and services. This might also include that. Generally, it's not going to include things that the buyer doesn't care about. So if there are certain things like consulting for businesses that are outside of the territory, that are not competitive whatsoever, that may be an opportunity. Or if there's certain carve outs of, like, the buyer only cares about this part of the business, then they may not include the non-compete to cover the full scope of the business. They may have the scope be more narrowly defined, so it's able to give the seller comfort. Now, these are all one-on-one conversations that the buyer and the seller are going to have, that they're going to have with their counsel, to be able to find something that feels good for both parties. Non-competes are almost an essential term of every single transaction, but how we can structure them in a way that is fair to both parties is an easy art. It is usually very easy to find something that works for both parties, that aligns with market expectations of not taking the business out from under the buyer, but instead having an ability for the seller to, if they need to, find some sort of employment post-closing with their skill set, that they're able to. And then same for term. Term is generally going to be 3 to 5 years. We see most non-competes at that 5-year mark. And then in addition to that, territory is generally going to be where the business is currently operating, and may also expand to where the buyer intends to expand the business. So all of those are generally going to be reasonable in scope, and most parties have no issues with those key terms. It's really just making sure that the seller feels comfortable, that they have an avenue, so that if something happens in the future, if that's something that they care about, that they have an avenue. That may include negotiations. We've included terms such as, if the seller would like to compete, then they can, or if they would like to seek out employment, that they would first let the company know, because most companies, if they don't have SBA regulations where they're not allowed to employ the seller post-closing, generally would want that expertise as a consultant or as an employee. So first letting them know, and if not, then it would be a certain scope or a certain territory that would be permissible, or something subject to the buyer's consent, which shall not be unreasonably withheld. So there's a lot of different ways that we can massage that to make it feel better for the parties. Now, something that a lot of people don't talk about is the non-solicitation part. So a lot of people talk about the non-compete, but typically this is actually going to be a more expansive either covenant in the purchase agreement, or it's going to be a more expansive restrictive covenant agreement that's a standalone agreement. And so one of the most important things to consider in addition to a non-compete is non-solicitation. And that's going to be a covenant whereby the seller will not solicit, will not engage with, or reach out to certain contacts of the company, which are typically customers, employees, and vendors. And this, of course, has to make sense post-closing. If the seller is going to be consulting post-closing and doing business development post-closing, we have to make that all congeal together well and come together well. But for the most part, it is even easier for the parties to agree to non-solicitation, because it's pretty clear that if you're soliciting the customers of the business or the vendors of the business or the employees of the business, that without a valid business reason potentially that is something that the parties agree to, it generally would be unacceptable for the parties. So non-solicitations, even in employer-employee situations, tend to be very easy to uphold, because it's something where if you have a client or an employee rather working for you, and they all of a sudden started their own businesses and sent out a mass email to all of your clients, that's just acting in bad faith. And I have gotten the call about what to do in that situation for someone who did not have a non-solicitation covenant with one of their key employees. Not something that you want to receive as a call as an attorney, so be sure it's something that you talk about with your attorney so that it's covered ahead of time. When it comes to navigating corporate law, entrepreneurship, and managing small businesses, experience matters. Dean Street Law is a boutique corporate firm specializing in mergers and acquisitions, and additional focus in real estate, commercial transactions, finance, and corporate governance. With over $10 billion in deals closed, Dean Street Law has extensive experience representing hundreds of clients in thousands of transactions, from small businesses to Fortune 500 companies. Whether you need startup guidance or advice on closing multi-million or multi-billion-dollar deals, we're your trusted partner every step of the way. Visit deanstreetlaw.com in the show notes to schedule a complimentary consultation. With that said, let's chat more about the employer-employee relationship. So the FTC ban, which is what everybody's been talking to, was proposed early on, implemented in 2024, but has since received a lot of feedback. So historically, non-competes, non-solicitations, restrictive covenant agreements have been governed on a state-by-state basis. And this was a federal regulation that said, on the whole, it is not permissible to include non-competes for reasons that it prevents people from seeking employment, it reduces competition, innovation, all of those things that the Fair Trade Commission is concerned about. Now, it has been the subject of a significant amount of debate and litigation, and so it's currently being reviewed. It's been stalled from implementation until all of the court cases involving it that are challenging it are resolved, and then going forward, it would be considered. So one of the key things to think about when structuring a non-compete agreement for employees is one, of course, making it narrowly tailored so that it's fair, reasonable, enforceable, still enables an employee to have employment after the engagement and doesn't unfairly hinder their ability to make a living. That is number one reason that the FTC cares about it, that state law cares about it, because ultimately you can't impede someone from being able to make a living. That's just not fair. And so that's one of the biggest considerations, but also drafting it in a way so that it either allows the jurisdiction, whether it be a court, if someone's reviewing it from a court perspective, to either rewrite it so that it's maximum enforceable what's written and only takes out what's not written, or makes it void. Certain courts in certain states will automatically void it. Certain of them will take the pen to it and edit it, or you could have a provision in there. So this is a severability provision that we're talking about. You could have that severability provision also say that the parties will come together and renegotiate and find something that captures the spirit of the intent. And so no matter what it comes down to, if you do have employment agreements or consulting agreements with non-competes in them, making sure that they're narrowly tailored, they're fair, they're going to be, you have a good severability provision in there so that if they are struck down, the whole rest of the agreement will still be valid and binding. And then also figuring out how else can we address these concerns. And so some of the ways that you can address those concerns are from having non-solicitation provisions, so making it so that they can't solicit clients or solicit vendors or solicit employees. Also having confidentiality provisions. And these are things that you're going to want to have in your seller non-compete as well. So covenants around confidentiality and use of confidential information, since it's hard to compete if you can't use confidential information. And then also non-disparagement clauses, so not being able to disparage or talk negatively about the other party in public spheres, privately, in a way that would damage their reputation or harm their business or harm their reputation. So those are a couple. And then also people are also thinking of like, okay, well, if I can't use this negative covenant, I will not do something. How can we change it to a positive? And so there may be incentive of complying with certain employee expectations, being an employee for a certain amount of time, then you get incentives, bonuses associated with that. So thinking of how you can creatively structure those relationships, there's still plenty of opportunity to have protection of the business post-closing, but how you creatively approach that is just a bit different these days with the current regulatory landscape than it has been previously. I hope that this has been helpful in giving you a bit of a spin on non-competes, non-solicitation agreements in mergers and acquisitions, and how you can think about those. For the most part, these tend to be the less heavily negotiated, but you will be surprised how many deals, in the addition to one or two terms of the purchase agreement, that there also is the restrictive covenant agreement or those specific terms within the purchase agreement that are still being negotiated. So it tends to be something that most deals aren't a big deal, but for the ones that are, it tends to be something that is heavily negotiated. So I hope this has been helpful. If you like this episode, please be sure to give it 5-star, subscribe, leave us a review, leave us a comment, share it with your friends on social media, tag us. That would mean so much to us. And if you haven't checked out my book yet on the legal aspects of buying a small business, I encourage you to do so. Thank you so much for all of your support. Cheers and happy deal making. Thank you so much for joining us on this episode of the Dealmaking with Laura DiFrancesco podcast. I hope you found today's discussion insightful and that it brought you one step closer to mastering the art of mergers and acquisitions. If you enjoyed this episode, please be sure to follow and subscribe to Dealmaking with Laura DiFrancesco on your favorite podcast platform so you never miss an episode. And if you found value in our discussion, please leave a 5-star review. It would mean the world to us. And share this podcast with your network, friends, and colleagues. For more in-depth resources, be sure to visit our website, deanstreetlaw.com, where you can find articles, guides, and more information on our services. Don't forget to follow us on social media for the latest episodes, updates, tips, and exclusive content. You can find us on LinkedIn, Search Funder, at LMDFrancesco on X, and at Dean Street Law on Instagram. Join us on our next episode where we'll explore more deal-making insights. Cheers and happy deal-making.